in 20 minutes from now.
Thank you, Sandile. Good afternoon, everyone. The topic I'm presenting on today is Section 138(5) of the Labour Relations Act, in particular, a recent history of how cases have treated the section over the last few years and why the provision is important to keep in mind. The agenda for the presentation is briefly as follows: a consideration of the purpose of Section 138 of the LRA, and then a consideration of the two particular subsections of Section 138(5). Finally, I conclude by mentioning some lessons that may be learned from the provision. In other words, why does one need to be alert to these provisions? So Section 138 of the LRA generally is provisions regarding arbitration proceedings. For instance, arbitrations that take place before the CCMA. The first important point then to consider is that this pertains to arbitration specifically and not to conciliations. Conciliations have their own set of rules insofar as the issues we intend discussing today are concerned. With that background in mind, we turn now to deal specifically with the provisions of Section 138(5) of the LRA. Before I get there, I must just mention that there's an important case, Heerden versus Marcus, which says that the constitutional imperatives for compulsory arbitration under the LRA is that the process must be fair and equitable, that the arbiter must be impartial and unbiased, and the proceedings must be lawful and procedurally fair. The award must be justifiable and consistent with the fundamental rights to labour practices. So that's a useful case to keep in mind when considering the context to Section 138 generally. Then we turn specifically to Section 138(5), and the two subsections contained therein. So what do they deal with? They deal with, very briefly, what happens if a party fails to attend at the proceedings. So 135(8)(a) deals with if that party is the referring party, and 135(8)(b) if the party who does not show up is the opposition. So if one looks at the provision, it says, Section 135(8) provides that if a party to the dispute fails to appear in person or to be represented at the arbitration proceedings, and that party had referred the dispute to the commission, the commissioner may dismiss the matter. So there's a few things to unpack about this particular provision. The first thing, as I've already mentioned, is that it deals with specifically the party who referred the dispute to the CCMA. So that would typically be the employee or the union. And the second thing that one must consider is the use of the term dismiss. So in other words, the commissioner may dismiss the matter if the party does not attend. Now, the issue about what it means to dismiss the matter has been the cause for some controversy and the subject of a number of cases which we intend to deal with over the course of this presentation. So the first case that one must take cognizance of is the case of Glencore Operations versus the CCMA. In that case, the applicant who was dismissed failed to attend at the proceedings. The matter was dismissed, and the applicant then arrived thereafter. The commissioner then decided to, because the applicant then arrived after he initially decided to dismiss the matter, he continued with the arbitration, and an arbitration award was ultimately made that found the dismissal to be substantively and procedurally unfair. As a result of that, the employer decided to take the matter on review. The court found that dismissal, and here we refer to the dismissal of the case as per the section, not the dismissal more generally of the employee's employment, is akin to striking off and/or a withdrawal. Where a party does not appear and had referred a dispute, it is not incongruent to conclude that such a party had withdrawn the dispute. Furthermore, dismissing a matter in the context of Section 138(5) means that the dispute is withdrawn. Alternatively, the other party is absolved, with the consequences that unless and until arbitration is requested again, the CCMA lacks jurisdiction the same way this court lacks jurisdiction over a deemed withdrawn review. An aggrieved party has two options. Either the decision to dismiss the matter is reviewed and is reviewed within the contemplation of Section 1581G of the LRA, or they can re-request for the arbitration of the dispute. There's no room for res judicata because the merits of the dispute could not have been resolved. So what this meant in terms of this particular matter was that the review was successful because the arbitration award was found to be a nullity. Why? Because the party didn't ask for either of those two options. The arbitrator on his own initiative decided to proceed with the matter. The next case that's worthy of consideration is the Solomons versus Food Lovers Market case, Kempton Park and others. In this case, both parties, the employee was dismissed by the Food Lovers Market. Both parties were not present at the arbitration, but there was a postponement agreement that had been signed. It was only signed by one of the parties. As a result, the commissioner decided to nevertheless proceed with the matter and dismiss the matter as per the section. The employee then sought to review the matter. The review was not opposed by the employer. The Labour Court held that since the matter had not been assessed, the commissioner cannot dismiss the matter. Importantly, the meaning ascribed to the word dismiss is akin to striking a matter from the roll. It was held further that the applicant may therefore request that the matter be re-enrolled for arbitration without the need to apply for a rescission of the dismissal ruling. And then in paragraph 14, the court said as follows: given the authorities traversed above, it may be necessary for the legislature to consider amending the section and be categorical and state that the commissioner may strike off the matter as opposed to dismissing the matter. Such legislative interaction will certainly resolve a situation where indignant employees would not have to contend with applications, be it rescission, if appropriate, or review, seeking to put their foot back into the dispute resolution area. Okay. So the CCMA then took heed of that and issued a directive on the 5th of October. As a result of the Solomons case, the CCMA issued a directive on the 5th of October to comply with the Labour Court's interpretation of Section 135.8a. The directive confirmed the view that the Commissioner is not at liberty to dismiss a matter where the applicant fails to arrive at arbitration, but may only strike the matter from the roll. Not only did they issue a CCMA directive, they also, with effect of the 24th of April 2023, amended Rule 30 of the CCMA rules, as well as introducing Rule 31C, which was incorporated to align with the interpretation of the Solomons judgment. So the amended CCMA rules, so amended Rule 30 states that if a party to the dispute fails to attend or be represented in any arbitration proceedings before the Commission, and that party was the referring party, the Commissioner appointed to arbitrate must attempt to establish the reason for non-attendance. If there appears to be a good reason for the absence, the Commissioner must direct that the matter be rescheduled for arbitration. Or if the absence is, on the face of it, willful or unexplained, or the Commissioner does not accept the explanation, the Commissioner may remove the matter from the roll. And then the second point we'll get to in a moment, but we'll read it for now, had not referred the matter to the Commission, in other words, Section B, the Commissioner may continue with the proceedings in the absence of that party or adjourn the proceedings to a later date. A Commissioner must be satisfied that the party had been properly notified the date, time, and venue of the proceedings before making any decision in terms of sub-rule 1. And then Rule 31C of the amended CCMA rules states as follows: it makes provision for the procedure to be followed to have a matter re-enrolled if it has been struck from the roll as a result of non-attendance at a previously scheduled arbitration. It provides that a decision to remove the matter from the roll must be sent to the parties within 14 days of the date of the hearing. If the referring party was absent from the arbitration hearing wishes to have the matter re-enrolled, that party must submit the request for re-enrollment to the Commissioner within 14 days of the referring party becoming aware that the matter was removed from the roll. The request for re-enrollment form must be served on the other party. Upon receipt of the request for re-enrollment, the other party has 7 days from the date of receipt to file opposing papers. And along with the amendments to these rules, the CCMA has also released pro forma forms that one can utilize for these purposes. And then the Rule 31C continues. It says, the Commissioner considering the request for re-enrollment may decide whether the matter should be re-enrolled based on the submissions received from the party. The Commissioner considering the request must issue a decision within 14 days from receipt of the answer from the other party or upon expiry of the 7 days, and the Commission must inform the parties of the decision. So this was the case up until recently, and as I've mentioned, the rules were amended to deal with this. And then there was a change once again. So Mahoba versus CCMA and others, In this case, the Labour Appeal Court disagreed with the interpretation in the Solomons case and held that a commissioner's power to dismiss a dispute referred for non-attendance by the applicant should not be exercised mechanically or unconsciously. A commissioner should apply his or her mind to such decision. The Labour Court importantly interpreted the word dismiss in terms of section 138.5 of the LRA to mean struck off the roll as creating legal confusion and being incorrect. In other words, it said that it would be stretching the language to say what the previous courts had said, which is that you can't dismiss outright, that there was always this option of having it re-enrolled. The interpretation of the Labour Court of dismiss would serve a purpose other than what it was supposed to convey. That's what I've mentioned, it would distort the language. However, that's not to say the only option is to dismiss. So it had held that the Commissioner has the power to dismiss the matters in terms of section 135.8 of the LRA, and the referring party may, if it is aggrieved by and disagrees with the dismissal ruling, apply to have the ruling rescinded in terms of section 144 of the LRA. However, the dismissal of a dispute due to non-attendance is considered as a matter of last resort. So there's two important things to remember here. In the previous decisions, the courts were expressed in saying that a rescission application would be inappropriate. Here they're saying that in the case where the commissioner exercises his or her discretion to dismiss, you would have to rescind. And I'm not going to go into any detail on rescission applications because my colleague Peter will be dealing with that topic in some detail in the next presentation. The second aspect to take into consideration, which is important, is that it's a matter of last resort. In other words, it's not the automatic response to say, well, the party's not here, the referring party's not here, therefore I must dismiss. It's one of the range of options that the commissioner has. So the court says, importantly, a dismissal consequent on the proper exercise of a discretion violates neither the provisions of the LRA nor constitutional prescripts, as the applicant was given the opportunity to have his or her day in court, but refused to make use of it. And here we say it's important to see the term the proper exercise of discretion. So the court also provided some guidelines as to what that means. And it's important to bear in mind that those guidelines are non-exhaustive. If it's the first occasion the applicant fails to attend the arbitration hearing, a lesser sanction than that of dismissal may be warranted. In other words, postponed to a later date or to a specific date, or postponed sine die without a specific date in mind. So the commissioner always has the option to postpone the matter sine die without a date. Matter can be postponed to a specific date with an instruction to the CCMA's case management office to do more than forwarding a set-down notice. That is, telephone if the number is available, and inform the applicant of a new date and remind him or her that the failure to attend the arbitration may result in the referral being dismissed. The CCMA can add section 135.8 of the LRA or the notice of set-down in order for both parties to be aware of the possible consequences of non-attendance. All right, so the CCMA then, in response to this case, issued a directive on the 27th of May, which became effective immediately on the findings of this case. CCMA directive effectively withdrew the prior directive that had been issued and made it clear that the commissioners have the power to dismiss matters in terms of section 135.8 of the LRA. However, as per the Labour Appeal Court, commissioners are directed to utilise their powers as a matter of last resort. In cases where the dismissal has been ruled, parties have a right, nevertheless, to apply for the ruling to be rescinded in terms of section 144 of the Labour Relations Act, read with the CCMA Rule 30. It also said that the CCMA will issue guidelines within 7 working days of the date of the directive on which factors may be considered when exercising the power to dismiss and how to deal with matters that are pending in terms of the CCMA directive on the determination of dismissals under section 135.8 of the LRA and rules 31A and B of the CCMA rules. These guidelines have not yet been issued, so it's likely to happen soon, and hopefully those guidelines will provide some more clearance, guidance on what the process entails. All right, so that's where we currently stand with the situation, which is to say that the commissioner, and this is the warning, the commissioner has the power to ultimately dismiss, and the consequences are then that the party must then seek a rescission. So that's section 135.8a. I now turn to section 135.8b. The section provides that if a party to dispute fails to appear in person or to be represented in the arbitration proceedings, and that party had not referred the dispute to the commission, in other words, was the respondent party, the commissioner may continue with the arbitration proceedings in the absence of that party, or adjourn the arbitration proceedings to a later date. So this provision's been less controversial, but there are some cases that are interesting nonetheless. There's the Fisher versus Mount Rochelle Lodge case, and that's a Labour Court decision. It says that as a matter of policy, CCMA hearings should not lapse into a pattern of repeated postponements due to a party's failure to attend. In this case, the Commissioner continued in the absence of the employer based on the following reasons. Prima facie, the employer had received proper notification of the hearing, and if he wished to deny it, he should have set out his case in an application supported by affidavits. The employer had not attended the conciliation phase. There was no formal communication with the CCMA by either the employer or its representative since the referral of the dispute. And you can see why the Commission may take less of a lenient approach here, because what they don't want is the respondent party delaying the process simply by non-attendance. All right. The employee wished to proceed in that matter, and the employer was anxious that the matter be resolved as soon as possible. And then section, as we mentioned at the beginning of this presentation, one must have regard to the principles that apply to this provision more generally and the LRA, and that is that the dispute must be determined fairly and quickly. All right, then we have the ShopRite Checkers dispute. It's another Labour Court dispute, and it says the discretion under section 130 in the section 1385B of the LRA is open-ended and subject only to common law requirement that it be exercised judicially. The result of exercising discretion in terms of that section is that a default award is issued, and in practice, the default award, unless it is rescinded, is then certified and may be executed. So once again, the risk here of not attending without a valid reason is that you get, well, even with is that you're going to have a rescission application on your hands, and that's not the most easiest process to deal with. The denial case, this is just interesting to bear in mind, as an obiter remark, said the default awards do not finally determine the substantive merit of the dispute, and accordingly should not be certified. So there's at the moment some lack of clarity on that particular issue, but what is clear is that you're going to have to rescind it if a default award is made. All right, so having said all of this and having dealt with the current state of play, why should parties take cognizance of this provision? Why should it matter? Well, it's important because there's very real consequences that may be meted out if you don't attend. That is that you're going to be faced with the matter being dismissed and potentially a costly and complicated process of having it rescinded. So it's important to notify the Commissioner if you'll be unable to appear, or at least send a representative to providing good reasons as to why you could not be present on an arbitration. And you would have to seek an application for postponement in that process. Bearing in mind, there's no guarantee of any application of that nature being granted. The failure to appear may result in the dismissal, dispute being dismissed, or an award being made in the party's absence, depending on which party is absent. As I've mentioned, this would then result in the need to have to apply to have the award rescinded in terms of section 144 of the LRA. The one thing that should be borne in mind was the CCMA has made all these changes to the rules. Are they simply now not to be considered? Well, no, not in terms of especially Rule 31C. That's because, remember, the Commissioner doesn't have to dismiss. He could say, I'm going to postpone the matter sine die. And then notion that in those circumstances, I think Rule 31C still has a role to play, which is to say you can utilize that provision to apply for a re-enrollment of the matter. And then you must ensure compliance with the timeframes, 14 days from the date in which the applicant became aware of the ruling award, of the ruling or the award. That's when the rescission application must be brought within that time period, and that's calendar days. So that is my presentation. Thank you very much, Sandelia.
I think you under your matched Nonkosi. That was exactly 20 minutes. Unless people want us to take break earlier than the arranged time, we can proceed. The next person is going to be Peter Musebo, who will be talking about, now that you want to rescind, after Andre has said what he said about you being not present or being present at the arbitration, what are the consequences? Peter.